Next, we have the Director General of the Litigation Bureau of the Ministry of Justice of Japan, Mr. Haruna Shigeru, as the third keynote speaker. Mr. Haruna will speak on the subject of the Litigation Bureau's international endeavors and contributions to further the development of international arbitration and mediation. Mr. Haruna, please, you have the floor.
Greetings to the distinguished participants here with us and joining online from around the world. I am Shigeru Haruna, Director General of the Litigation Bureau of the Ministry of Justice of Japan. Today, I would like to introduce the Litigation Bureau's international endeavors and contributions to further the development of international arbitration and mediation. At the beginning, please allow me to introduce the Bureau and the state litigation system of Japan. Litigation refers to the activities of court proceedings, such as filing complaints, claims, and evidence regarding disputes involving state interests. The Ministry of Justice performs such as activities in a unified and centralized manner on behalf of the state. This is called the state litigation system. There are two types of disputes related to state interest: civil disputes and administrative disputes. The specific cases related to these disputes are called state litigation cases, and work related to these cases are administered by our Bureau and our local branches, that is, the Litigation Department of the Legal Affairs Bureau and the District Legal Affairs Bureau. The basic principle of state litigation system is to contribute to the establishment of the rule of law in the domestic and international society. To carry through this principle of rule of law, our Bureau performs the following three activities. First, our Bureau carries out lawsuits of civil and administrative disputes related to state interests. In order to secure the rule of law, as well as ensure proper harmonization between the interests of the state and the rights and the interests of individuals, our Bureau is working to lead legal disputes to appropriate resolution, including carrying out state litigation cases whose outcome could have a serious impact on national diplomacy, politics, administration, and economy. Secondly, our Bureau also plays a role in preventing legal disputes. We contribute to appropriate solutions of legal issues by providing legal advice or support with respect to inquiries from government ministries and agencies regarding legal issues that may develop into future legal disputes. Thirdly, in addition to these two activities related to domestic affairs, our Bureau also provides international judicial proceeding support, such as legal support for international lawsuits related state interests. Specifically, our Bureau provides legal advice and support to state ministries in international legal disputes related to state interests, as well as preventive legal support for international legal disputes. As I will explain later in detail, our Bureau has also been committed to the formulation of international dispute resolution rules. In this manner, our Bureau has been contributing to the rule of law in the domestic and international society through such activities, carrying out lawsuits related to states' interests, preventive legal support, and international judicial proceedings support. Now, I'd like to introduce our Bureau's two international endeavors and contributions to further the development of international arbitration and mediation. The first is holding the Tokyo Forum on Dispute Resolution. As a part of Justice Affairs diplomacy, the Ministry of Justice of Japan has been holding many international seminars and forums on civil and commercial law and dispute resolution with other countries. This forum has held, one of them is the Tokyo Forum on Dispute Resolution. This forum has been held in Tokyo in 2021 and 2022 and is co-organized by the Ministry of Justice of Japan, UNSTRAL, the United Nations Commission on International Trade Law, and ICSID, the International Center for Settlement of Investment Disputes. In December of 2022, the forum addressed the theme of anchoring new approaches to the core principles of due process and fairness. We are honored to have Ms. Anna Giovanbure, the Secretary of UNSTRAL, and Ms. Meg Kinnear, the Secretary General of ICSID, attend the meeting in person. The forum was held over 2 days, and it consisted of the UNSTRAL session and the ICSID session. The UNSTRAL session addressed the stock-taking of developments in dispute resolution in the digital economy, which our minister mentioned in the video message. The ICSID session was dedicated to discussing the significance of 2022 exit rules and its impact on practice. Eminent practitioners and researchers from Japan and overseas in fields such as international commercial arbitration and mediation and ISDS, investor-state dispute settlement served as panelists. Attendees from more than 30 countries and regions participated. Our Bureau was in charge of the exit session, and we selected the topics and panelists in close contact with ICSID. After the forum, we received words of appreciation for the fruitful session from many participants, including Ms. Meg Kinnear, who moderated the session. We believe that holding this forum in Tokyo and disseminating the content of discussions by eminent practitioners and researchers in the field of international arbitration and mediation will contribute to further the development of international arbitration and mediation. We will continue such endeavor in the future. The second endeavor is a commitment to the formulation of international dispute resolution rules. As a minister mentioned in the video message, our Bureau has been committed to the formulation of international dispute resolution rules by participating in the drafting process of legal instruments at relevant international conferences of international organizations. With respect to UNSTRAL, our Bureau has been actively participating in the amendment project and drafting process of the UNSTRAL arbitration rules and related rules. By having our staff attend the UNSTRAL Commission session and Working Group 2 session on dispute settlement as representatives of Japanese government. For example, in the drafting process of the expedited arbitration rules, which were adopted in 2021 we propose that the application of the unstructured expedited arbitration rules should depend on the agreement of the parties. We also propose that case management conferences, for the purpose of narrowing the issues and evidence addressed during the arbitration, should be included in the content of the expedited arbitration rules in order to conduct efficient proceedings. Both of our proposals are fully reflected in the expedited arbitration rules. As for exit, our Bureau also participated closely and actively in the amendment project and the drafting process of the 2022 exit rules, including the 2022 exit arbitration rules, by having our staff attend the conference of the contracting parties to discuss the revision of the exit rules as representatives of the Japanese government. In the drafting process of the 2022 exit rules, we proposed, for example, inclusion of the principle of good faith in the conduct of arbitration proceedings, as well as of case management conferences in order to enable more efficient proceedings. And these proposals are fully reflected in the 2022 exit arbitration rules. Both answer arbitration rules and exit arbitration rules are widely used in international arbitration. We are proud of the contribution of the Japanese government to the formulation of better international dispute resolution rules, which will lead to the further development of international arbitration and mediation. We'll continue to our endeavors to actively contribute to the formulation of international dispute settlement rules in cooperation with international organizations such as UNSTRAL and EXIT. In addition, I wish to refer to project named Stocktaking of Developments in Dispute Resolution in the Digital Economy, which a minister mentioned in the video message. Proposed and founded by Japan, this project was launched by the UNSTRAL Commission in 2021, conferring on the Secretariat the mandate to monitor the changing landscape of dispute resolution in the digital economy. This project is to compile, analyze, and share relevant information on trends in dispute resolution in the digital economy. Specifically, this project is conducting research and analysis on issues such as a legal framework on enforcement of electronic awards, the way to conduct case management conferences, new forms of presentation and submission and evidence in arbitration, and the way to conduct online hearings. The Ministry of Justice of Japan is confident that this project will yield positive outcomes for dispute resolution in these times of rapid digitalization and beyond. Our Bureau will continue to contribute to the rule of law in the domestic and international society. And as part of that, we'll continue our international endeavors, which will contribute to further the development of international arbitration and mediation. Thank you very much.
I thank Mr. Haruna for his speech.